Welcome to Indianomics. Today we put the spotlight on a very important Supreme Court order to the state electricity regulatory commissions to raise tariffs and allow DISCOMs to run on commercial lines. Were it not for the tariff issue, this order would have grabbed the headlines in all newspapers. The Delhi power distribution companies have actually taken the DERC, that is the Delhi electricity regulator, to the Supreme Court, asking for the recovery of their past dues amounting to 27,200 crore rupees. These past dues in jargon are called regulatory assets. The Supreme Court, in response last week, gave a broad order to all the state electricity regulators as follows. First, it said that the tariff decided by the SERCs shall reflect the actual cost of power. Second, the accumulated dues or the regulatory assets should ideally not exceed 3% of the annual revenue requirement of the DISCOMs. Third, these regulatory assets or past dues must be liquidated in 3 years, either by raising tariffs or getting the state governments to pay. The current backlog of past dues have to be paid back in 4 years. That's the telling point of the order. It has more. Joining us now are two former power secretaries, Mr. Alok Kumar and Mr. Pradeep Kumar Pujari. Mr. Pujari has also been the Central Electricity Regulator Commission's chairman. I'm also joined by Nikhil, the director and senior analyst at Bernstein. Gentlemen, thank you very much indeed for your time. Mr. Pradeep Kumar, if I may start with you, sir, since you have, worn both hats as power secretary and as chairman of the CERC, do you think this moves the needle a bit? There have been several national tariff policies which have told the SERCs to do exactly this. Liquidate the past dues in 3 years, 7 years, whatever. Nothing has moved them. Will the Supreme Court order move the needle, at least for Delhi?
Thank you. What Supreme Court has said is already there in the various statutes. The 3% limit, liquidation of the regulatory assets, and when regulatory assets are to be created, they are supposed to be created in under exceptional circumstances. Now, the issue is that not only the statute, but also the various, I'll not call it direction, but various letters that has been issued from the ministry also had asked the regulator to take necessary steps. Unfortunately, when the regulatory assets are created, at the same time, the regulator should have included a roadmap within the time frame during which these regulatory assets are supposed to be liquidated. So unfortunately, this has not happened. So I'm really happy about this direction that came from the Supreme Court. And I'm sure that the various regulators, state regulators who are having or have to take necessary action will now take action to liquidate these regulatory assets within the time that has been stipulated by the regulator. The rule and the policy says that the old regulatory or the legacy regulatory assets are supposed to be liquidated within 7 years. However, the Supreme Court has now put a new timeline of 4 years. So they need to be regulated. I'm sure that all the regulators will comply with this direction.
Oh, you feel so? Let me get first thoughts from Mr. Alok Kumar. Sir, it is a large number. I mean, DERC itself has to pay 27,000 crores in terms of legacy assets. Their annual amount is much smaller. It's like 20,000 crores or thereabouts. How are they going to clear this backlog? And it is to all SERCs. So if you go to a state like Tamil Nadu, which is, a huge offender, their accumulated losses or accumulated dues, are 89,000 crores. And in any given year, their annual revenue amount is only 91,000 crores. I mean, this doesn't look even feasible. What's your sense?
Thank you for having me on this show. I will add what Mr. Pujari has said. The Supreme Court has very clearly said it's a regulatory failure. And the regulators are prepared to work under dictation. So that is the sorry state of affairs. But there are some silver lining. If you see the new scheme, the Government of India has floated the RDSS. One of the pre-qualification which participants have to meet every year is the no new regulatory asset has been created and past has been liquidated. If you read the order carefully, they accept Madhya Pradesh, Rajasthan, and Tamil Nadu. This is not a very widespread problem in the country. There's some states where regulatory failure has been very prominent.
Yeah.
But I'm happy to see, if you leave the case of Delhi for a moment, the 4 states which have given their affidavit, they said that we have not created any significant regulatory assets post 2020. So that means this carrot and stick approach by Government of India is working, number one. Number two, DRC also wrote a letter to the Government of Delhi saying that they should take it up, that private sector DISCOMs should be able to participate in Government of India schemes. What happens? This has been my view.
Yeah.
Normally, the Government of India has been excluding the private sector DISCOMs from schemes like RDSS and even other. That is not done because the consumers in those companies, they face tariff hike because grant is not given. So there is also a administrative view which needs to be changed, that under the regulatory oversight, the private DISCOMs should also be made fully eligible for participating in Government of India schemes. Third, I'll say there has been a lot of debate why Ministry Power has come and made rules. Now, I'm very happy that most of the rules which are made when I was in the ministry, now Supreme Court has welcomed. He says, endorsed them. They said there is nothing can be more clearer than tariff policy.
Yes.
So now the issue is that we need the stick from APTEL and Supreme Court, and we need the carrot from Government of India to see that these things doesn't happen. Past dues are huge, and I personally feel like Tamil Nadu has been giving a lot of support to the DISCOMs from their budget. I think part of it has to come from budget. All of it can't be passed through tariff, and some parts should come from the tariff rise. Most important is going forward, the DRC has to give up this approach of giving only 8% of DRS for recovery of capital as well as interest, whereas carrying cost is also more than 8%.
Yes.
So if DRC should correct at least the future stance,
so what is this DRS?
Past can be addressed.
What is DRS?
DRS is called the deficit recovery surcharge, which DRC has been allowing as 8%. It's a laughable. Carrying cost is more than 8%, and you expect to recover everything 8%. That's all I have to say.
Fair point, sir. So let's get a market angle from this. Nikhil, as both the former power secretaries are saying, when the word comes from the Supreme Court, it has a much larger, force of law than a national tariff policy. Policy is a guidance. A Supreme Court judgment is law. So do you think we are going to see, more money flow through? If not all the 2.3 trillion rupees of past dues, will something flow through to the power sector?
So absolutely. I think, as Mr. Alok Kumar said, it's a carrot and stick approach, the stick being the Supreme Court and the APTEL, and the carrot being schemes like RDSS by the central government. So definitely a big positive step in the right direction for the broader power sector. In terms of flowing through, if it does, it doesn't impact the P&L of these distribution companies. It impacts the cash flow, which itself is a big benefit. The most immediate beneficiaries would be power distribution companies in Delhi, assuming that's where the case was regarding. And the 3 there are, one is Tata Power, Delhi Distribution. The other 2 are owned by Reliance Infrastructure. We don't cover these names, but they are the ones who stand to gain the most. And beyond that, if we expand it to other parts of the country, then CSC is another one, which has regulatory assets, although not all of it might be approved. And so those are the large ones I would say are immediate beneficiaries.
Yeah, I agree. Adani Energy also is there in some states. But generally, the DISCOMs are likely to get more power, more money if the law is implemented. I'm going to take a bit of a liberty with all of you. I'm not going to restrict it only to the Supreme Court's order. Since I have 3 very knowledgeable people on power, I will meander into other questions as well. But Mr. Pujari, just to finish this argument for the moment, do you think it will be more tariffs, or will state governments have to cough up? Like Mr. Alok Kumar said, Tamil Nadu has been coughing up, and they have to, because their losses are really huge, or their dues are really huge. But do you think the state governments will be forced to take this order seriously, or they are, likely to be in contempt of the court?
Yeah, one thing is very clear, that the Supreme Court has rightly recognized that it has to be done in a partnership. Both the state and the regulator have to work out a solution. And as you understand, the structure of the is such that the regulator is supposed to determine the cost reflective tariff. Now, how much of that is to be passed on to the consumer? The state government can always intervene. And if they intervene, the scheme is very clear, saying that the gap, you cover it on the subsidy. So now, suppose the legacy regulatory assets are to be clear, and depending on how much it impacts the consumers, the state government, the specific state government, looking at the local context and the consumer mix, what is the position of the DISCOMs, whether there is an affordability issue. Considering that, the state government has to take a view how much it will allow, or how much should go to the consumers, how much the state government will cover it through subsidy. So I don't think it is a general rule that a particular sort of approach will be followed. My understanding is that every state government with a state-specific approach they will take, looking at 2 or 3 major things: the financial health of the DISCOMs, the consumer mix, what is the present tariff of the C&I sector vis-a-vis the domestic sectors, and what is the financial position of the state government. So considering that, I think the each state government will take a view on that. That's my take. There will be no sort of one should fit all sort of approach. And this is very clearly, Supreme Court has said that both the state government and the regulator have to work it out. So this is how the probably approach will be.
I'll come to this point in just a minute. Let me, before I take my first break, give our stock market viewers some big gift from the people who are here. Mr. Alok Kumar, very quickly, I mean, I saw your excellent piece in the Mint about how the grid capacity has fallen short because of the waivers given to renewable energy guys. If you can very briefly tell our viewers which part of the power ecosystem today looks most profitable. I mean, where is the demand-supply gap? Is it for transformer makers? Is it for electricity construction companies? Is it, for DISCOMs, for power generators, renewables? Which is the best sector now?
I'll say best sector is transmission, because it's a most essential component, natural monopoly, and their dues are mostly paid. You can't live without transmission. So go and invest in transmission first.
Okay. All right. Actually, I have to take a break. But all of you Bazaar viewers, just watch. There is a wealth of information coming on power sector from 3 of the best minds in this space. We're going to a break, chart busters for you. But you can catch the full conversation after market hours.